Welcome everyone to ID Law 2021. We're so excited to have you all here. I will now leave the floor to Christiane Wendehorst and Mr. Nicolas Forgo to take us into the opening speeches.
Well, thank you so much, dear Federal Minister Edtstadler, dear Dean Zöchling-Jud, dear colleagues, dear friends. Welcome to the ID Law 2021 conference, which is the second conference on innovation and digitalization in law, organized by the Department for Innovation and Digitalization in Law. This year's conference is devoted to the Digital Services Act package, i.e. to the two proposals for EU regulations tabled by the European Commission in mid-December 2020. The proposal for a Digital Services Act and the proposal for a Digital Markets Act. This conference has the provocative subtitle, Revolution or More of the Same. And the platform economy is a very highly contested area, as we all know. Policymakers in different regions of the world have been struggling for some time to find the right regulatory approach. Austria has recently moved forward and enacted the ambitious Communication Platforms Act, which I'm sure Federal Minister Edtstadler will mention later. I'm truly looking forward to 2 days of intensive discussions about whether or not the European Commission has, with this eagerly awaited regulatory package, struck the right balance. The Department for Innovation and Digitization in Law, which is headed by my dear friend and colleague Nicolas Forgo, who is jointly with me chairing this introductory session, was founded in October 2017 to embrace the opportunities and to meet the challenges posed by the digital transformation. The department is growing fast, and we will soon be 4 full professors and a very large team of young scientists who are eager to contribute to the academic debate on innovation and digitization in law. As was the case with the first ID Law conference, which took place last year, the young generation has been very much in the driver's seat of organizing this conference. And I wish to take the opportunity to thank the team of enthusiastic and very committed young researchers who have prepared this event. And the fact that it is the young generation who is in the driver's seat is illustrated by the fact that those young people will take a leading role in introducing the topic and in sharing the sessions. 2 of them, Catherine Altobelli and Sebastian Schwamberger, will immediately after welcome addresses give a short overview of the package, which is why I will refrain from giving any separate introduction myself. And other young people will continue moderating the panels we will be having today and tomorrow. Please allow me to add a few housekeeping issues. I guess all of you are meanwhile pretty familiar with Zoom webinars. Just to mention that by default, your video and audio will be switched off. To participate in the session discussions, please use the Q&A chat where you can write down a question. If you want to speak instead, please let us know by clicking on the raise hand button. We will unmute you once it is your turn to speak. So to recap, you have 2 alternative options for participating in the discussions. Both the Q&A, which means the moderator will read out your question, or you can alternatively intervene orally, which means you will pose your question orally once the moderator has enabled your micro. Please note that in the latter case, your voice will be recorded. Dear colleagues and friends, the department is part of the Faculty of Law of the University of Vienna, which is, just to explain to our guests from other time zones, the oldest and largest faculty of law in the German-speaking world, founded in 1365. It would, of course, be a bit exaggerated to say that the University of Vienna has been strong in digitization since 1365. But one of our leading mottos is that we have been asking the right questions since 1365. And I hope that this conference today and tomorrow will follow the tradition of asking the right questions and maybe also give good answers here or there. The department is immensely grateful to many players and in particular to the faculty leadership for the great support received and for putting internationalization, innovation and digitalization quite far up on the list of priorities for the next few years. It is my great pleasure and honor to immediately greet our Federal Minister for EU and Constitution, Mrs. Magister Edtstadler. Federal Minister Edtstadler, it's a great honor for us that you have agreed to address the audience, and please, the floor is yours.
Thank you so much, Professor Wendehorst, for inviting me. Thank you also for the kind introduction and the invitation to speak. Ladies and gentlemen, thank you for giving me the opportunity to talk to you to a very important topic, to open this conference on innovation and digitalization in law. I would like to congratulate all the organizers for choosing such a current topic, the proposed Digital Services Act and the Digital Markets Act. The issue we as Austrians and the European Union are discussing is central because it acknowledges the role of the digitalization. And we have shifted in the last year so many things in the digital world. Our lives are taking place in the digital world in so many fields, from shopping to e-schooling, to watching TV, to even attending scientific conferences like this conference. And to be honest, I would really prefer of seeing you in person, standing in a so-called Hörsaal at the university, talking to you, because it's still another feeling than talking to a camera, not seeing anyone, not having emotions and the emotions in the room. But we are happy that we have this opportunity to talk in this way. And therefore, a big thank you again to you, Professor Wendehorst, and the organizers of this conference. Well, the COVID-19 pandemic has boosted digitalization. That's in some areas a really good thing, but there is also a downside. And we have to fight that we can fight this downside of the digitalization. We are all used to having regulatory framework for most of the fields I already mentioned, as from shopping to falling in love, to be very concrete about the range of topics we are talking about. But currently, we do not have a framework for all or for most of these areas. And therefore, we have the situation that we need to find a regulatory framework. And the starting point is now the DSA and the DMA. 20 years, to be very clear on that, 20 years after the e-commerce directive came into force. The European Union is now trying to design a framework that fits our digital world. This means making rules that embody the basis of the European Union, the internal market, and our fundamental rights. And in my role, not only as a Minister for European Affairs, but also for Constitutional Affairs, I have come across the underlying topics in many ways. Last year, you know that I have proposed a bill introducing a regulation for communication platforms on a national level. I would like to be very clear on that. It's the first trial to have a regulatory framework for that in Austria for social media platforms who are active in Austria. This law is already established. It's into force since the 1st of January this year. And it includes things which are also now proposed in the DSA. For example, the duty for platforms to establish an effective complaint mechanism, the duty to name a point of contact for communication with the authorities. And that's something as a former judge, also experienced in the past. It's very often we do not have a contact point to these platforms. And there is the need of increased transparency for these platforms, and this is also laid down in this bill. However, as mentioned, it only establishes this duty for platforms which are active in Austria. And I would also be very clear on that, and I always have been very clear on that point. Of course, I'm supporting a European solution. The digital world is not knowing any borders, it's not knowing any countries. It's working in not only the European Union, but also in Europe and the rest of the world. And therefore, it must be our clear goal to have at least a European framework for all these questions to be addressed. And I'm pushing in that direction. And I also had a lot of discussions with the European Commission in that regard. I was very clear when I had a conversation only 3 weeks ago with Thierry Breton, the Commissioner responsible for that also. And on the other hand, I have to mention that I'm really happy that we did it, that we do have this Austrian regulatory framework, that it is already in place. And we are awaiting the next steps, because the platforms have to establish now their complaint systems and name the persons, the point of contact until the 1st of April, because now we have this period where they can bring all the things in order. Well, the matter is urgent, I would say, and that was why I was pushing for that also on the national level. I would go so far that I say, if we, the Austrians and also the French, wouldn't have pushed so much in that regard, I'm not sure if the Commission, because of the COVID-19 crisis, were already there, but now we have the DSA and the DMA on the table, and we have to start the negotiations, because it's urgent to find solutions. It's not only about hate speech, it's not only about helping the victims who face such messages, but it's also about our democratic society and the interaction and the communication we are seeing. This communication is now mostly happening online, and as the last years have shown, this interaction appears to be dysfunctional. We feel to be in a sphere of open discussion while we are communicating in spaces which are designed to hide dissent. This is a genuine risk for our democracy, and I do not even start to mention the risk of interference of foreign powers. With the decision of platforms to delete Donald Trump's account, we again realize the power of platforms they have in regulating not only what is said, but also who is part of the conversation, who is allowed to mention what he or she is thinking. And while traditionally, when it comes to the freedom of communication, it is best when the state steps back from any interference in order to guarantee freedom of speech, the current situation, I'm convinced, requires the state to act, to give people the possibility to participate in this communication. As the design of some platforms hinders free speech, the state has to act. That's what I would like to underline. As digital platforms affect all of us, even those who are not participating, I see that the best way to find rules is a democratic one. Still, I believe that a regulation that does not include the knowledge and skills of platforms will fail. So we have to get into action with the platforms. We have to discuss with the platforms. We need their know-how and their initiatives from the platforms also. And I can guarantee you, I did it during the phase when we drafted the law. I was in contact with so many platforms who are acting worldwide. And all of them said, yes, we know that we do have a responsibility. And yes, we want to fulfill and deal with this responsibility. And now it's our duty, and it's a duty also of politics. And I see it also as my task to stay in touch with them, to surveil the situation, and to have a framework where we can, minimize the risks also for our democratic society. Besides the issue of hate speech. Other questions need to be addressed, and only a few sentences on that. E-commerce has become such an important part of our economy that we also need more regulatory framework in that regard. And the latest events in Australia, and Professor Wendehorst, we were discussing that also, where a proposed law required platforms to pay for journalism shared on the platforms, lead to a complete Facebook blocking, time-wise, of the shared news. And in the meantime, I think from Austria, looking to Australia, the issue seemed to be resolved, but it was a reminder of the power of these platforms. And I think we have to be aware of that fact. When it comes to digitalization, the pandemic has boosted a lot, and a lot is really, can be seen positively, but a lot has to be done. And therefore, I think it's really time now to negotiate on the European level, the DSA and the DMA, but we also have to think more than the European way. We have to talk also with the US, and we have to find solutions. So it's the best way to have a conference like that in a digital way. Again, I would prefer to be directly where you are. Still, I think it's good to keep in touch also between the science and politics to find best solutions in the best way for all of us. Thank you again for having this opportunity. Thanks for keeping in touch, and all the best for your conference.
Well, thank you so much, Federal Minister Edtstadler, for addressing our audience, and in particular also for explaining to our audience, many of whom are not from Austria, that important Austrian initiative with the Communication Platforms Act and also its relationship with developments at European level. And also, of course, for reminding us of how complex the situation really is. So be assured that the University of Vienna and all the colleagues who are in the audience and who come from many places all over the world will work together and discuss over the coming few days the really important problems which you mentioned. So thank you again so much for coming and for addressing our audience. And I now see with pleasure that we were able to overcome the difficult situation with our Zoom account. And I see the Dean of our faculty, Professor Zöchling-Jud. Please, Britta, the floor is yours.
Yeah, thank you. And sorry for being late. Somehow it has been a technical prank. So dear Minister, dear Christiane, dear Nikolaus, dear colleagues, as Dean of the Vienna Law Faculty, it is a great honor for me to welcome you today to the annual conference of the Institute on Innovation and Digitalization in Law. I would like to start with a personal remark. It is not a matter of course that scientific conferences are opened by a minister. Rather, it is an honor for this event, the Institute for Innovation and Digitalization in Law, and thus also for the law faculty. So I would like to thank Minister Edtstadler on behalf of the organizers and also on behalf of the law faculty. The general topic of this conference is this Digital Service Act package, means the European Commission's proposals for Digital Service Act and the Digital Markets Act. The choice of this general topic is characteristic for the Institute and its tasks, namely to accompany legislative processes in the field of digitalization scientifically from the beginning. Highly recognized experts from all over Europe and from different legal fields will examine the proposal, compare the legislative initiative to the status quo, and discuss the future of digital services. I would like to thank Christiane Wendehorst and Nikolaus Forgo for their commitment and congratulate them on this top-class conference. And now I will pass over, and I wish to everybody very interesting discussions and very interesting 2 days. Thank you.
Thank you so much, Britta, for that introduction, and I hand over to Nikolaus.
Thank you very much. I can be very brief. Thank you, Christiane. Thank you to all our members and participants to this conference. I'm very pleased to be with you. And I hand over to the first agenda point now, which is undertaken by two of the people who are really in charge of the organizational aspects of this conference, to Karoline and Sebastian, please.
So, perfect. So Karoline and I will give you in the next 20 minutes a short overview of the Digital Services Act and the Digital Markets Act, starting with some numbers behind the two proposals. Digital services have evolved considerably over the last 20 years since the adoption of the e-commerce directive. This is evident especially when it comes to e-commerce, where 70% of Europeans shop online today, compared to 9% in 2002. Up to now, 20% of European businesses are involved in e-commerce, and 40% of them are using online marketplaces to reach their customers. While platforms did already exist in the 1990s, the scale, reach, and business models were in no way comparable to the current influence in the market and the functioning of our societies. 76% of Europeans regularly use video sharing or music streaming platforms, and 70% are using social networks. Digital services also have a huge impact in online advertising, naming 28.9 billion euros pending in Europe in the first half of 2019, which means a growth rate of 12.9%. While it is clear that digital services are vital for the backbone of the internet, they have also become the source of risks and challenges for the users, which are addressed by the Digital Markets and the Digital Services Act. The Digital Services Act seeks to tackle three main problems that appear when providing information society or digital services. The first problem are the serious societal and economic risks and harms of online intermediaries that in particular arise from the misuse of services for illegal activities, such as the sale of illegal goods or the dissemination of illegal content or the provision of illegal services, such as services infringing consumer protection provisions. These risks are especially posed by online platforms because illegal content shared through such platforms can be amplified to a wide range of audiences, and the core of the platform business model is to match users, presumably with the most relevant information for them. This can lead to the so-called filter bubbles, as well as to the misuse of the users, which are vulnerable to manipulation by ill-intended individuals or organized groups. Finally, the fundamental rights of the users are not only ensured when illegal content is disseminated online, but also when legal content is posted or disseminated online, but removed by the platform erroneously. The second major issue are the legal barriers for digital services. Due to the societal and economic risks and harms, national legislators, as we already heard by Federal Minister Edtstadler, have proposed or already adopted certain legal acts. The most dominant example is the Austrian and the French Act. The Austrian, we already heard, and the French on hate speech. Furthermore, the German legislator already adopted or proposed the law to protect minors. This all leads to a legal fragmentation, together with legal uncertainties that stem from the contradicting application of CJEU case law on the e-commerce directive. This leads to huge barriers for digital services, especially preventing SMEs from scaling up and creating advantages for large platforms that are equipped to bear the costs. Finally, the supervision arrangements across the digital single market are not effective and currently leading to the third problem tackled by the Digital Services Act. The Digital Services Act, or the proposal, aims to solve these problems by setting out the contribution to the proper functioning of the internal market for intermediary services as a general aim in Article 1.2a. The functioning of the internal market, Article 114 TFEU, is also the legal basis of the proposal. In line with this aim, the staff working document set out several special aims that specifically address the problems with information society services as special objectives. What remained in the proposal is Article 1.2b, which sets out that the regulation aims to set out uniform rules for a safe, predictable, and trusted online environment and protecting fundamental rights enshrined in the Charter. To achieve these objectives, the regulation applies to intermediary services provided to recipients of the service that have their place of establishment or residence in the Union, irrespective of the place of establishment of the provider. A similar scope is already known from the Platform to Business regulation, but there's a main difference because the DSA does only cover services that are provided, while the Platform to Business regulation also covers services that are offered to be provided. So that limited scope may lead to certain problems when looking to the due diligence obligations in Chapter 3. Speaking of Chapter 3, the structure of the DSA is divided into 5 chapters. The first chapter is on the general provisions in Articles 1 and 2, on the subject matter, the scope, and the definitions. The second is on liability of providers of intermediary services, where the DSA maintained parts of the liability regime of the e-commerce directive, but for reasons of harmonization, put this regime into the form of a regulation. Chapter 3 contains the characteristic, the asymmetric due diligence obligation, depending on the nature of the service and the size of the digital service provider. This means that certain obligations, such as points of contact of legal representatives, are applicable to all service providers. But if the service provider is also providing a hosting service, additional obligations arise, especially on notice and action. If this hosting provider is also an online platform, again, additional obligations arise. And if it's a very large platform, again, additional obligations arise, namely trusted flaggers and risk management obligations. Besides these asymmetric obligations, Chapter 3 also contains transversal provisions concerning due diligence obligations, for example, on drawing up codes of conduct at the European level. Chapter 4 is on the provisions concerning the implementation and enforcement of the regulation. This includes especially provisions on the digital service coordinators, which are the primary national authorities. The digital service coordinators of the member states form the European Board for Digital Services, which is an advisory group for the supervision of providers of intermediary services. The enforcement via national digital service coordinators and the European Board for Digital Services could somehow be compared to the enforcement mechanisms in the GDPR with the supervisory authorities and the European Data Protection Board. But when taking a closer look, it is obvious that there are major differences between them. In addition to this enforcement with the national authorities and the European Board, Chapter 4 also contains provisions on the supervision, especially for very large online platforms, where the European Commission can have a major role. Finally, the Chapter 5 contains Articles 71 to 74, which are especially on the deletion of certain provisions of the e-commerce directive and an amendment to the directive on representative actions. The Digital Service Act is designed to work within the existing horizontal as well as sectoral European legal acts. By setting out in Article 1.5 that the regulation or the proposal is without prejudice to all these legal acts and names some legal acts or uses broad formulation. First, the regulation is at the horizontal level without prejudice to the e-commerce directive, where the regulation only replaces in a way some provisions of the e-commerce directive. Second, the regulation can have huge overlaps with a number of acts that also address the problem of illegal content and suspicious activities online, such as the Audiovisual Media Service Directive, Union Law and Copyright and Related Rights, Terrorist Content Online Regulation, and e-evidence, or the regulation of marketing and use of explosive precursors. Furthermore, the regulation may also have overlaps with the redress and complaint mechanisms in the Platform to Business regulation, and maybe also with the Union Law on the protection of personal data or Union Law on consumer protection and product safety. However, when looking into the recitals of the proposal, the reference in Article 1.5 may seem a little too broad. The recitals are outlining that some legal acts are considered as lex specialis, and that Article 1.5 is only for reasons of clarification setting out that this is without prejudice. However, due to the broad formulation, Article 1.5 may also cover legal acts that are not considered as lex specialis, but which would still be unaffected by the Digital Services Act. What is less problematic or more clear is the relationship between the Digital Services Act and the Digital Markets Act, which is in the focus of the presentation of Catherine in the following.
Thank you, Sebastian. So good afternoon also from my side. So similar to how Sebastian presented the DSA, I will be providing a brief overview of the background and objectives of the EU ambitious plan in the DMA to ensure that digital markets remain fair and competitive. So starting from the Commission's rationales for regulation, the proposal acknowledges that despite over 10,000 online platforms currently operating in the EU, a small number of large online platforms capture the biggest share of online services and are the ones defining the factors for future innovation, consumer choice, and competition. It follows that there is a widely shared view that a few of those online large platforms operate as digital gatekeepers. Indeed, these platforms control the key channels of distribution favored by exploiting a number of factors, such as the strong network effect of having a large user base, their role as intermediaries of transactions between end users and business users, and the large amount of data they accumulate by tracking and profiling end users. These characteristics of gatekeepers result in substantial control over access to digital markets, which forces many business users to depend on these gatekeepers and potentially leading to unfair practices vis-a-vis these business users. In this regard, the Commission emphasizes three core problems. First, there is a power imbalance between these large platforms and the users and possible competitors. Second, having control of the largest online ecosystems, SMEs and startups are faced with substantial barriers to enter the market. And third, there is a large risk of leveraging, as gatekeepers can exploit their dominant position on one market to then extend it to another market. The final core issue identified by the Commission relates to a lack of contestability. In fact, current regulatory standards do not sufficiently address the practices by digital gatekeepers, leading to weak contestability and enabling core platforms to create a conglomerate ecosystem around them. So, to understand the objectives of the DMA, it is important to first define its scope. So the scope of the DMA is limited to a closed list of 8 types of digital services, which are referred to as core platform services. And these include, as you can see on the slide, online intermediation services, such as marketplaces and app stores, online search engines, social networking, video sharing platform services, number-independent interpersonal electronic communication services. To put it simply, a chat like WhatsApp would fall within this category, operating system, cloud services, and finally, advertising services. However, only because a digital service qualifies as a core platform service, it does not mean that its activities result in issues of contestability and unfair practices. it follows that the DMA applies only to those providers which have been designated as gatekeepers of one or several of those core platform services. Providers of core platform services can be deemed to be gatekeepers according to the DMA if they have significant impact on the internal market, operate one or more important gateways to customers, and enjoy or are expected to enjoy an entrenched and durable position in their operations. More in-depth analysis on the threshold to qualify as gatekeeper will be presented in the following session on the DMA. So, to tackle the previously mentioned issues, the proposed Digital Market Act aims to achieve three core objectives. First and foremost, to strengthen the internal market through harmonized rules at the EU level. In fact, the Commission stresses how regulatory initiatives by member states are incapable of addressing these issues and would, of course, lead to fragmentation of the internal market. The second objective is to ensure contestability of digital markets, enabling SMEs and startups to enter it. And thirdly, to ensure fairness of the relationship of digital gatekeepers vis-à-vis business users. Nonetheless, these specific goals aim to achieve the more general goal of preserving and promoting innovation, quality of digital products and services, the degree to which prices are fair and competitive, and the degree to which quality and choice for business users and for end users remains high. Finally, next slide, please. Finally, the Commission emphasizes that the proposal for a DMA is consistent and coherent with existing policies. In terms of policy provisions in the same policy area, it builds upon the platform to business regulation without conflicting with it, while the P2B regulation sets common transparency obligations for all online platforms, regardless of their size or position. The DMA further addresses concerns relating specifically to large online platforms designated as gatekeepers, as we have seen in the previous slide. Moreover, the DMA is also deemed to be fully coherent with the DSA, as Sebastian already mentioned. Indeed, while the DSA horizontally regulates a number of issues as presented, the DMA is specifically concerned with the negative economic effects on the digital single market caused by small number of large online platforms. In addition to this, the DMA complements also other union policies. Firstly, it is coherent with the Commission's digital strategy by ensuring a fair and competitive digital economy, which is indeed one of the three main pillars of the strategy. Secondly, the proposed DMA covers the gap of existing competition law rules. Indeed, the DMA addresses practices by gatekeepers either falling beyond the scope of existing competition law or which are not being addressed in an effective manner to ensure a contestable and fair digital market, as I have explained earlier. In addition, it also complements antitrust enforcement by minimizing the detrimental effects of unfair practices ex ante without negatively impacting existing ex-post intervention according to existing national and EU competition rules. Finally, the proposal is also in line with other EU instruments, including the Charter, the ECHR, applicable consumer law, and the GDPR. As the DMA, in terms of data protection laws, can also support it, especially its enforcement through transparency obligations on consumer profiling. So that is all from our side. Having provided the audience with an overview of the two proposals, we hope to have built the necessary foundations for the following sessions. And thank you very much for your attention.
Thank you very much, Catherine.